Hey, good evening, Angela. How are you doing?
Oh, pretty good.
Yeah. Okay, so welcome to Spin Legal tonight. And I'm asking a question discussing this because of something that occurred in the USA. And we know that, hey, the what happens in the USA has an impact here. And I thought this topic might have some relevance here. And the question has been raised in the Supreme Court of America as whether the court presentations by members of the court or by members presenting their case to the court should have time limits. And the question here is the longest argument of the current term, which was of the term that's just closed, which is basically October till April, was an argument of nearly 3 hours that was on the case that involved Donald Trump's sweeping global tariffs, of which the court ultimately struck it down. Now, I'm thinking to myself that such an argument is seemingly just.
Mm-hmm.
Right? I don't know what you think about that.
Well, the thing is, I mean, you're doing this, it's quite obvious because these things must have come in from lower courts. And generally, you present them things through factums, affidavits, and other documentation. Nobody testifies at a Supreme Court. You get arguments only.
Okay, but isn't this test?
And basically what happens is when it comes from a lower court, it's already the decision's there and people are arguing why that decision is either the correct decision or the decision needs to be changed.
Yeah.
To some way or another. And there's reasonings given through the factums and arguments that are provided.
Yeah. Fair. So what you're saying is the Supreme Court is entirely different than the other courts, and that is the reason why you're not generally arguing the case. You've already got a case that has decided that, and taking the thing of Donald Trump's tariffs, that the earlier case has already decided yay or nay. And you're now arguing as to the correctness of that decision.
Mm-hmm. It goes up. Yeah, and you're arguing basic on either a standard of review or on an appellate basis, whether there was a correct or incorrect interpretation of the law.
Yeah.
Okay, so these have to be brought before, and the lawyers, and then there's also intervener lawyers, okay, if there's special interests involved in the arguments.
Yeah.
And because first of all, the court has to decide whether they're going to admit certain interveners.
Yeah.
Okay, and whether these interveners really have anything to add to the arguments. Okay. Like you can't just walk in and say, "Oh, I want to be part of this. I'm intervening." Like you have to have.
You've got to be a related party. So in terms of that tariff argument, you might well be representing a global corporation or something of that nature.
Global corporation. You could represent a country that has had trade relations and who could be impacted by the tariffs. Yeah. There's different things that would be taking place between the parties that would have a right to have an audience.
Yeah.
Okay? It doesn't mean that the decision of the court, well, we're going to award you, but these people help the court get informed so they can make an informed decision based on what people are arguing.
But an intervener would have also been heard at an earlier hearing, wouldn't they?
Possibly. Yeah. I know we have some interventions going up in the court systems in Ontario, okay? Because one of them has gone to the Ontario Court of Appeal.
Yeah.
And our organization, Ontario Paralegal Association, was an intervener in that particular case. And they were approved as an intervener. And there was a few other groups that were also approved as an intervener.
Yeah. But again, with that,
because they were talking about whether that the groups that were coming in had any relative things to say about the topic at question.
Okay. But again, in that particular case, the Ontario Paralegal Association had an intervener in the original case anyway.
Yeah, they did. And they just brought it
Yeah.
up to the Ontario Court of Appeal. You have to apply every time you go.
Yeah.
Okay,
Oh,
so if you want to be an intervener at,
yeah.
say, if it went to divisional court, then you got to apply for the Ontario Court of Appeal. Then if
Yeah.
it gets to the Ontario Supreme Court, oh, so help me God, then you got to have the intervener status again.
Yeah. All right. Okay.
But
So
then we would be part of the Ontario Canadian Supreme Court.
okay. All right. So this American system thing was and I guess it was a speech by Chief Justice John Roberts, who basically said that the speeches concerning that particular event were way too long. And he's not talking about just the Trump tariff question. He's talking about a whole heap of questions where those involved took way too long to give their speeches. And he's at the heart of saying that they're looking into how they can trim it down. And there's another one, Justice Samuel Alito from Texas, also Supreme Court Justice, basically from Texas, he's later saying, accusing those involved of too much speechifying. It's almost as if they are kind of, are they kind of, thinking about a future political career?
I don't know. It's very strange because I think their court, unfortunately, has become too politicized.
Yeah.
Okay? Because of some of the decisions that they've made. I can't say all of the decisions are politicized because we don't hear about all of them.
Yeah.
But the ones that seem to be the biggest, most important cases seem to have been politicized in some way or another. Like in one case, they're slapping Donald Trump on the hand. In the other case, they're saying, oh, you go ahead. Anything that is part of the role of the executive is fine with me. You've got immunity. So there's a lot of things like that, I think there has to be, I don't know what it is. Our Supreme Court in Canada, we don't have all of this politicizing.
We'll get to that. We'll get to that in a minute because I'm going to ask you about this. Got one further question first, though, that needs to be asked. Is this a case of news agencies trying to apply and be sensationalist?
Sometimes journalists don't have anything to talk about. It's a slow news day, so they'll come up with something.
Yeah. And part of the problem here is that in the US, I'm seeing that it's basically news has become, particularly in the US, news has become make it sensational or go home.
Yeah, unfortunately, because like almost news is being equated with entertainment at some level. Like Fox News. They don't call themselves a news agency anymore. They call themselves an entertainment agency.
Yeah.
Okay, because people watch Fox News and everybody's got an opinion.
Yeah.
And it's just that's why I don't watch it. I like to watch things that are more the hard news, that are straightforward, and breaking news, things that are constant, because that way, let me form my own opinion on it. Just tell me what's going on. Let me form my own opinion on it.
Well, I have watched Fox. I've watched CNN. I've also watched CBC News. I've watched the BBC News.
I watch all sorts of them.
Yeah, so yeah.
The different news agencies that I do watch are mostly public agencies in the different countries.
Yeah.
And other things like Al Jazeera.
Oh, yeah. I was going to say Al Jazeera.
Yeah, Al Jazeera is very interesting how they cover things.
Yeah.
They have other countries too. BBC is also another interesting news. Sky News.
The thing is, I'm very much a critic of the BBC, particularly when it comes to home news. They have unfortunately ended up being too defensive because there are people in UK that want to trim BBC funding.
Yeah, and I think that's the same here in Canada. We've got people say, "Oh, defund the CBC." I don't know whether that's really a good idea.
Anyway, we've moved off.
Yeah.
We've moved off onto another
going
angle.
as usual.
We moved off onto another angle, and that has proven that essentially news agencies are being very sensational about pretty well everything, aren't they? Okay. So here's the question, though. So how does the Canada Supreme Court differ from the US Supreme Court?
Well, the Canada Supreme Court, we have our 9. They have their 9. But they're mostly, to some extent, politically appointed. Okay? The president just puts them to a vote through the Senate, to a Senate committee that tends to be dominated by whoever dominates the Senate. And they pick and they ask them questions. They tend to be more on a partisanship basis. And they get appointed. So there would be somebody who they would find, maybe somewhere in the depths of Tennessee somewhere, and find somebody who's really backwoods in their thinking, and then they would elevate them somehow to the Supreme Court. Right? And people would be in there.
Stop criticizing our Tennessee brethren. You know, there are good lawyers in Tennessee. I bet you there are.
Yeah, but in Canada, what we do is choices of people to be put forward are put forward by, say, like the Canadian Bar Association, other federal organizations of lawyers, different attorney general, different types of organizations that have a lot to do with dealing with justice issues. And then they come up with a list. And from that list, and people interview people, and then from that list, then the Prime Minister through the PMO, then they make an appointment. Okay? So it doesn't originate from partisanship necessarily.
Well, one of the things that I was surprised at, some of the appointees, the Trump appointees at the Supreme Court, is, and not generally anything wrong with people who are academics, but usually you do get academics that are appointed to judicial positions, but not generally straight out of academia, straight to the Supreme Court. In Britain, in Canada, you generally get academics who will be promoted to justice,
like
and they will then
were at a lower courts, like say maybe at the Ontario Superior Court, then they went up to the Ontario Court of Appeal.
Exactly.
Made it in, like Moldaver, for example. They made it into the Court of Appeal, and then they afterwards. So there's a lot of them that went through that way. Same as so it looks like more of a position where people have had a chance to see how they operate as a judge.
Yeah.
Okay. Rather than pointing somebody, some lawyer in backwoods Alabama, and say, "Oh, you'd make a great Supreme Court judge."
Well,
no,
I think I would make a good Supreme Court judge.
Yeah, so would I. Yeah, well, I think we all could. Hey, from Invictus, they should go through Invictus and pick us.
Well, I've got the right approach. I always listen to both sides of the story, and then I kind of say, no, my side is right. Okay. So one of the suggestions that Roberts made is that they want to limit Supreme Court schedules to 60-minute argument sessions. That's not to say that there's that they will make their decision within that 60 minutes. Is that case A comes before the Supreme Court, you've got 60 minutes to argue it, go.
Yeah, that's not enough time for some cases, which may be of more complexity.
Yeah,
you're making legal arguments here.
Yeah, and irrespective of which side that you fall upon,
regardless of what side you're looking at, you're making legal arguments.
Yeah, and for example,
they have to listen to these legal arguments and take them into account. Each of these things are put into a transcript, and then the Supreme Court judges take that with them, and then they go and they argue among themselves, and at a certain time they will publish them.
Yeah.
Okay? And they decide if there's a dissenting opinion, then they might do a dissenting opinion.
Yeah.
Okay? Like they do here. They do it in Canada too.
And on the questions such as that the tariff question, I would have to say that that long speeches, a session of more than 60 minutes would be have to be warranted. I get it that probably the vast majority of cases, 60 minutes would probably be more than adequate for most cases.
Yeah, some cases it's just a matter,
Yeah.
you're on there for 60 minutes. You're going to argue why you think your side is right. The other party comes in and they argue why they think their side is right.
Yeah. And what would
go away and they make a decision.
And what we're talking about at the Supreme Court level is, we've now gotten the facts down to 2 or 3 particular issues of 2 or 3 particular issues that matter to this case, right? Yeah. Those 2 or 3 particular issues should A occur alongside B, alongside C, right? Yeah. That's the type
I think sometimes this also relates to American television shows, because whenever you see on TV, when a lawyer appears before the American Supreme Court, they talk and it's over with in 15 minutes.
and in fact, actually, that was what Justice Samuel Alito was referring to. The too much speechifying was basically saying that what has happened is they went from debates to things on live TV during the course of COVID. And of course, they've stayed available on live in a live version since COVID. And basically, once you introduce it into a live situation, rather than the people are in the Supreme Court in Washington, once you've introduced the live background and you've got now the TVs coming in there, you've changed the whole meaning of how that Supreme Court is managing itself.
Yeah, exactly. And the thing is, what I like about those courts at the higher level is the fact that the judges, like, you don't hear a whole lot of bickering back and forth. There's a lot of, first of all, there's some argument, and then judges ask questions of the person making the arguments.
Yeah.
And it's very interesting because sometimes they play devil's advocate, and sometimes they will try to base it on certain areas of law and how a person would fit their arguments within that. And it's interesting listening to them.
Yeah, but what Justice Alito was basically saying is that during the pandemic, when the court switched to virtual arguments, the justices would question in order of seniority rather than free-form hot bench style that had been used for decades, individual questions. So there would be much less the longevity of sessions would be less. Sorry, that's what I meant to say. Yeah. And they were expecting that if that continued on, you'd have shorter sessions.
But it depends on what the seniority of the judges or seniority of the lawyers appearing before them.
Actually, it could be seniority of the lawyers, I think.
Yeah, and that.
No, sorry, hang on. The justices would put questions in order of seniority rather than free-form hot bench style that has been used for decades. So it's the seniority of the justices.
Oh, the justices, yeah.
So
as long as each of the justices would each have a kick at the can for some of these things, because if you have the 7 or the 9, usually they have 7 on an average, then they would each have a chance to go on each side and ask. Yeah, because there's specifics that each of them have an interest in, because some of them came from a commercial background, some from more of a criminal background, that sort of thing, to give them to give a very good, fresh, and diverse perspective to when the justices go back and they go away to be able to write that decision.
Yeah,
and then whoever takes the lead of writing that decision.
Absolutely, and I think that both the hot bench and the justices asking questions in order of seniority has value, but I also think that I do sort of think that probably freeform means that you're probably lengthening each session.
Yeah, because somebody says, "Oh, I have an idea." Yeah.
Yeah, exactly. It's like, sorry. You, instead of being third in list for speaking, now you're speaking number 12 because you already had your session, you already asked your questions, and now you've got additional questions that you're asking.
Yeah,
But,
and it could be a very valid question. Yeah.
Yeah, but again, there might well be validity in that because, in fact, just because I didn't think of the questions in round number 1, and I asked 5 questions, based upon very valid questions. You ask a question that now reformats some of my thinking, and assuming that the justices that follow me don't bring that question up, how does that question get raised?
Yeah.
Right.
Yeah, they had it where the other judges would just cut everybody off right in the middle of their answer.
Yeah.
That's what at one point they would do it, and I don't know if that's a great thing to do, but I don't know. It's like you're trying to chair a meeting or something.
Yeah. Oh yeah.
It's the same kind of thing you encounter. You want to make sure everybody has their say and everybody gives their input.
Yeah.
Each of the justices have a fair shot at the can.
Yeah.
You want to make sure that each of the perspectives are shared, and that that each of the lawyers representing the interest before the court all have a chance to put their 2 cents in. Okay, and that's a balancing act that the Chief Justice has to achieve.
And remember that what we need to talk about is actually the nature of oral argument within the higher courts. If I'm putting a case to the judge and we just had a 3-day trial and I'm putting the case to the judge, I'm likely to be saying summing up the judge a lot of the evidence that he's heard, a lot of the reason why it supports this particular premise in law, and not some other premise in law, and we would go into that, and then we might run the cases that we believe. I believe that if you look at case A, such and such the rule occurs, but you've also got to taper that with case B, where this other rule occurs. So the combination of these rules matters in this particular case, right? And you could end up with an oral argument that is large. Now, when it comes to the higher courts, when it comes to the Court of Appeal or to the Supreme Court, the question at hand is one of, it's about the much narrower scope. Because, for example, the lower court judges are all agreed on A, B, and C. They're just not agreed on D, E, and F, right?
Mm-hmm.
And now the argument is about how will the Supreme Court or the higher courts, the Court of Appeal and the Supreme Court, see the questions on D, E, and F? And maybe when you go to the Supreme Court, the Court of Appeal, you've now gotten A, B, C, D, and E answered, and F is the one remaining question, and that is why you're now at the Supreme Court. So essentially, it's all about one issue being argued at that Supreme Court.
And it's a legal issue. Sometimes you're defining terms that are in statute, or you're defining terms that have come from earlier arguments from lower courts, even lower appellate courts, and you're bringing that forward and trying to make an argument. Because this is one of the things where the Supreme Court has to decide these things, because the Supreme Court and the justices in the Supreme Court are very aware that whatever they say and what they decide has high precedential powers, that the lower courts generally have to follow what they decide. Bases on what they decide in terms of law, what their questions of law is.
Mm-hmm. Yeah.
Yeah, so they're very careful. That's why they just don't make a decision right away when people go and make the arguments. They have to go back and they argue among themselves about this. They do research and they have clerks in their
Yeah,
offices that help them with the research and come up with potential answers. And
yeah.
then when they come up with some kind of direction, when they have a majority, for example, somebody would write for the majority decision. And then if they're really far apart, somebody would write for the minority position.
And that is, in probably 90% of all Supreme Court cases, even in America, there is a single decision that is made, and there might be a secondary judge who actually supports that decision, but believes that you must also include
Yeah,
these other points.
yeah.
And so you might
We
get
have
a
that
primary
decision.
decision.
Yeah. Yeah, because they have that. A lot of times they have a unanimous in Canada where they have a unanimous decision where the Chief Justice would just go out and they would make that decision and they would write it. And then they have other people, they would write it and it'd be the same. But sometimes they would have like a minority, which is not necessarily disagreeing with the majority, but they would say, but I would add this,
Yeah.
for
Oh, yeah.
consideration, which
And we've
actually
given,
useful when you're going back down in the
yeah.
lower courts, and looking and say, look, they concluded this, that this is also an important factor to consider when this sort of cases arise.
Yeah. And for example, in a particular case, the Chief Justice, or whoever's summing up for the majority, might well be saying, "I believe in these 5 points. List the 5 points out. This is backed up by prior case law, and you quote the cases where they are." And the person who's adding a minority opinion might well be saying, we don't disagree with the 5 points. We believe there are 6 and 7 points. There are actually 7 points on here that apply in certain situations and only certain situations, and that you must consider these as well.
Yeah. And then there was some decisions there in the US. It's all like very often the conservative wing and there's a liberal wing, they disagree. And they'd have somebody writing for each side of it.
Yeah.
And it's always interesting to see their perspective, what they each see,
Yeah.
and try to analyze how each side looks at the situation.
Okay. I've got one last question. No. Okay. Another question, which is important. Okay. So does live streaming of the Supreme Court make a difference?
Um, Sometimes I think it could be starting to play for the cameras,
Yeah.
for some people. Hey, if they can kind of learn how not to play for the cameras and just continue to do what they're doing and not play for their cameras, they might not have an issue. But what tends to happen is sometimes when you put any kind of cameras in courtrooms, especially some lawyers, they like to grandstand, here I am,
Yeah.
and there they are, they're going to be making their thing. And I think sometimes that might even lengthen some of their positioning and posturing.
Yeah, that bothers me as well, because I agree with you that the lengthening, the posturing, etc., especially because when you wind the clock back before the pandemic, the numbers of Supreme Court decisions that were, or Supreme Court arguments that were being made in public was fairly limited. As not to say that you couldn't go to Washington, walk into the Supreme Court and walk into a session of the Supreme Court. That is everybody's right.
Yeah.
But that is a whole different ball game than live streaming.
Yeah, exactly. And the same as when they were showing on, I think there was something that was on the Supreme Court in Canada. I was watching that and I was fascinated. That was actually quite good. Watching that, it was interesting.
Yeah.
How they had our justices. They do things in a very different way because I've seen the American version too, and I've watched them. But they do a lot more of the televising and all that other stuff in the US because they like to have open courts, open accountability. That's part of their vision of things. Ours is more where there's accountable courts and that sort of thing. And people can still walk in and out and watch, right?
Yeah.
And decisions have to be made public, that sort of thing. But there's quite a bit of difference when you do live stream and televise them.
Oh yeah. Well, obviously the most famous of the court cases in America, I could not imagine being having the same in the UK or in Canada with the O.J. Simpson trial. There was so much there that we were getting to see. We, the members of the public, were getting to see not only the actual trial, but we were seeing the argument behind as to why, can we show the glove?
Yeah.
The legal argument associated with it. Right. Well, that's the most obvious one. But there was a question of that O.J. Simpson was not on the stand.
Mm-hmm.
So can they ask him to try the glove?
Yeah.
That's a valid legal question.
It's a valid question. And the thing is, he was not put on the stand, so you couldn't ask him.
Yeah. And I believe that Judge Ito made the wrong decision in that regard.
Mm-hmm.
Right?
Yeah. There's always these things, because the defendant doesn't have to appear. Yeah. And you don't even have to prepare a defense, right? Because your option is, because you're forcing the Crown to prove their case. If you feel the Crown hasn't proved their burden, why do you have to put on a defense?
Yeah. And it's like, yes, was there any blood really under that shell?
Yeah, exactly.
That's the degree of questioning you're doing in questioning the evidence, aren't you?
Yeah, of course, you can cross-examine everything the Crown does, right down to the nth degree.
Yeah.
And then not present a defense.
Yeah, absolutely. Okay, so I think we concluded that probably live streaming does make a difference. In the current era, I also have to ask the question whether there's a political impact in some of this.
Oh, yeah, absolutely. You get people out on the street who are armchair critics of the courts. Okay? And they'll go on and says, oh, how come the Supreme Court got rid of minimum mandatory sentences? And they should have mandatory sentences. And the thing is, they don't understand that the Supreme Court is not political. It's not set up to be political. It could decide on the law and on the basis of the Constitution and what the rights of the various parties are.
Yeah.
Okay? They can't just say, oh, I have to make this decision because this is good for the government in power. They can't do that.
Yeah.
Okay? They have to make a decision that's based on law. And sometimes people get all bent out of shape because they think that the Supreme Court is too liberal. They got activist judges. I don't think so. I mean, people who get up to that level after they've been judging and they go from the superior courts and then up to the Court of Appeals and then they go up to the Supreme Court of Canada, that sort of thing, they're not going to be activist judges.
Yeah.
But they have a lot of knowledge of the technocratic aspects of the law.
We have a different ruling than the US.
Yeah, in the US, they tend to be because they tend to come from more partisanship. They tend to sometimes lean right. That's why you have the conservative faction and the liberal faction in the courts. Yeah. We don't so much have that in Canada because I don't know who would be the liberal or the conservative faction in Canada. Sometimes there's a justice in Canada that might be consistently voting in a particular way, but it doesn't necessarily mean you have a quote unquote liberal faction or conservative faction, because that's not how they come up that way.
Well, one of the things when I was at law school, we were talking about the House of Lords as it was at that particular time. One of the things that they stated that the House of Lords requires out of judges that were, and now the Supreme Court in the UK, that they require out of judges is that they give up their political alliances. So if you were a member of the Conservative Party or Labour Party, you were no longer allowed to actually say that. You could no longer be a member of that political party.
Yeah, and judges can't vote in Canada either. They're not allowed to vote. And this is something that a lot of people don't realize, that we have to be nonpartisan here.
Yeah.
Okay, because judges can vote and then they put political signs on their lawns and hey, wouldn't that be making a mess of it?
Well, I was going to say one thing about that the political impact of that is that if you've given up, it doesn't mean to say you don't have political persuasions. Everybody does.
Yeah, everybody
right?
does. Like they have their own ideas about
Yeah.
what's right and what's wrong, and
exactly.
Viewpoints, philosophies of justice.
But the whole point about the Canadian system is that it's actually about putting up arguments, legal arguments, not political arguments.
Mm-hmm. Yeah. Yeah, in some states they have even more where they actually run for election. Hey, some of these judges, they actually run for election, and then they get elected, and they tend to be more where they're not accountable to the Constitution, they're accountable to the people that elected them.
Yeah.
And that becomes very difficult where you're not necessarily weighing things in the legal interests of all the parties.
Well, in fact, a good lawyer may well be a liberal who's arguing a conservative style case.
Mm-hmm.
Right?
Yeah. There's been cases I've even had to take where like a person's very religion, where they're really evangelical religion, where I've actually defended that person's right to exercise their evangelical religion, and on basic grounds of where their rights were infringed upon. And I would put forward where they were discriminated against and how that could be corrected.
Yeah.
And I'm not religious at all.
Yeah.
But what I look at is that the law doesn't have politics and the law doesn't have religion. Okay? Yeah. But I look at what the client interest is, what the client wants to achieve in terms of outcomes.
Yeah. All right. So, okay. So thank you everybody for being with us. And if you need to contact us, you can do so at 905-688-5598. And Angelo is available at Angelo@weareinvictus.legal. And I'm available at Peter@weareinvictus.legal. Of course, we're hosted today by Invictus Legal. And the website is weareinvictus.legal.
Yep.
So there we go. And the other thing that is important to remember is, Angela?
Yeah, is what you heard today on Spin Legal, and whether it's this show or others in our series, is not legal advice. If you need specific legal advice, please contact a paralegal or a lawyer. Okay? Yeah. As said before, paralegals are allowed to go to some courts in Ontario, but not all of them. As a lawyer, you can go to any of them. But basically what you need to do is talk, and sometimes you can screen and see whether this is something we can handle for you or whether we need to send you to a lawyer that we know. We're hoping at some point to get a lawyer in our firm, or somebody might become a lawyer in our firm.
Yeah.
But anyway, seek legal advice. They will be able to help you with any questions that you have that are specific to you.
Yep, exactly. All right. And well, thank you for being with us, and enjoy your week. And yeah, well, and we'll see you next week, next Tuesday at 6. Thank you.
Okay. Bye.